The initial counterclaims, there's some cost associated with that, but in the NPE case, I didn't put the cost because you don't have any claims. Yeah.
The original idea of patents was to give somebody an exclusive economic benefit for whatever they invented. And if you're not practicing entity, you're not getting any direct benefit out of owning it. Has the Supreme Court, it sounds like something that the Supreme Court would eventually need to decide, that a non-practicing entity really, if nobody's making any money doing this.
Well, presumably there's a tail that goes back to the patent owner. Presumably the non-practicing entity bought the patent from the original patent owner, or is the original patent owner gets some sort of a kickback, a percentage of whatever monies they're able to raise. I mean, there's a difference. Depends on the situation, but presumably the patent owner has some financial interest or receives some remuneration on the patent itself to end up in the hands of the NPE. These things don't just fall out of the sky for them.
So you're saying that they're just kind of buying the rights to enforce it?
They're buying the right.
There is a product somewhere.
There may not even be a product anywhere, or maybe a defunct product.
That's what I'm asking. There's no product. Where's the damage?
You have to actually have the product, otherwise you lose it.
Nope.
That's established law.
It's just an idea.
Established law. Yep.
The reason why is for biomedical, though, correct?
I mean, there's lots of reasons why, you know.
That was the main reason why they still allow this. Yeah, like trolls are essentially abusing it, but it's to protect biomedical research. It's the main reason why you have non-practicing entities and patents.
There's lots of reasons for patents. Industries have different uses and utilities for patents. Big pharmaceutical companies, they reap hundreds, lots of rewards based on their patents for their thing. But at the same time, that sounds really complicated and really elegant. Seed companies have the same issues. So, corn products and soybeans and the attendant fertilizers and weed control, all of that's tied up big industry, and a lot of that is protected by patents, and very important patents and very lucrative patents. So to say that it was intended for one or the other, I'm not sure is entirely accurate. So then there's some initial settlement discussions going on. You've got an assessment of your case. You're going to reach out to the other side and, hey, you clowns, we don't infringe. Why are you bugging us? And you go back and forth to see if there's some understanding you can reach. You can convince them that they don't infringe. You can convince them that their patent's bad. But those arguments really aren't going to go very well with the NPE. They don't care what the arguments of the merits of the case are. They only care about, and I'm speaking very cavalierly, okay? I'm talking about NPEs, right? They only care about extracting some revenue from you, and ideally, the maximum revenue that they can extract from you. It's a negotiation from their perspective. They've wielded the hammer, and now it's an opportunity for them to negotiate, open negotiations, and find out who you are, what you're about, how much money you make, and how much money you're willing to pay them to go away. That's the game here.
So, who's doing this back and forth? Is it the lawyer doing it, or is it us doing it?
Yeah, it should be the lawyer doing it. I know, I understand the cost sensitivities. I understand that. I get that. But you have to understand the legal framework, and you will be talking to a lawyer on the other side. They're handling the discussions on behalf of Macrosolve. So all you guys are brilliant people, but the legal world is an odd world, and then the patent world is esoteric.
I agree. And they're meant to do that job, that's what they should do, but I want to highlight, I think there is another $50K cost involved above for them to go back and forth on that. $50K on initial defense is only on the opinion,
Yeah.
but there might be another $50K before you get to the bullet number.
Yeah, no, I agree. This is just basically the opening foray. This is sort of the cost to get into the situation, and sort of understand where you are. What do I have in my, what cards do I have in my hand? That's where we're at right now. What cards do I have in my hand? And what's the other side really, going to bid, right?
Is this the phase where they would depose you and
No, we haven't got to that part yet. Right? No.
Let's get through this and maybe there'll be more questions.
Yeah, perfect. So I have litigate ... This is where it really starts getting expensive in a big hurry. You've got to file an answer. They filed a complaint that says you guys infringe. You're going to file an answer that says, no, we don't. Your patent's invalid. You guys are big bullies. Leave us alone. And that's kicks off the start of a lawsuit. Relatively speaking, that's inexpensive depending on what sort of counterclaims. You could do it really cheap. All you guys basically going to have the same answers, so some of it might be cut and paste for many of the defendants. If you elect to, you don't want to be in Texas, so we're going to fight being in Texas. There's ways to say, I don't want to be in Texas, I shouldn't be in Texas, I really should be in Virginia. All these are expensive things to do that may or may not be successful, and in Eastern District of Texas, once a case is filed there, they like to hold on to it there. Plus, what all you guys do on the internet and everything is as applicable in Eastern District of Texas as it is up in Virginia. So jurisdiction, those types of issues aren't very successful typically. So that, from my point of view, that might be money that's not well spent. Then the judge is going to want you to sit down in a room for a prescribed period of time and try and settle this case, so you don't really have to pursue it in the trial. And they may supervise those discussions, they may participate in those discussions, or they may just ask you to verify that you've had the discussions themselves. Preparing, that's travel time, that's attorney time, sitting in a room with the other side. And then you set up the proceeding. How are we going to do this? When is, what pleadings, what documentation, what evidence, what materials are due on what dates? When are we going to set this trial? When are we going to set time for discovery to be closed? When are we going to set time for expert reports to be due? That's this pre-trial conferences and stuff. Again, none of these things have really small price tags. But the big thing, the big hammer you guys have holding over your head is fact and expert discovery. It is tremendously expensive. This is why, at least in the United States, litigation is so expensive. The judges will give you a lot of freedom as plaintiffs to get information from the other side. So, they're gonna want to see all the emails. They're gonna want to see all your engineering descriptions. They're gonna want to understand as much as they can about you, your sales data, who you're selling to, where this stuff is going, what are your profit margins, all these sorts of things, to understand everything that they could possibly need to bring this case to trial, all the facts. And you're going to need that information back on them too. So it's a two-way street. The difference is for the MPEs, they only have to produce this information once for all of the defendants. But you defendants, again, only have to produce it once back. But the issue is that you're all having to do the same thing on your own specific set of data. These are some of the examples of the types of things that everybody needs to go through. Interrogatories is a list of questions. They get a prescribed number of questions. They throw it over to you. You have to answer. It's the basic things that you could answer in the sort of in a paper document. Just fairly straightforward questions most of the time, but sometimes they can be very complicated. And this stuff just takes time and energy. I need to talk to my client. I need to understand what the issues are. I need to know what the answers are, and then I got to frame them in a way that I'm answering the question, but not giving away too much information. And it's a mess. But this is, unfortunately, our legal system. In the U.S., we freely have open discovery. If you ask for it and it's legitimate to your case, you're likely going to get it if you're a plaintiff. And the same thing on the defense side. Other jurisdictions, other courts are a little bit less willing to force people to divulge information back and forth. You can see the price tag on that is very expensive, and that can be a long period of time, depending on your jurisdiction. It could be many months. It could be upwards of a year in some cases. It depends, but it's a lot of time and energy, a lot of legal time. This is where your depositions are going to occur. This is where your interviews are going to occur, all that sort of thing.
So the first point, filing an answer, is that after, so include on top of the initial consultation where you
Yeah.
so
Filing an answer is it's a specific document you file with the court saying, I don't infringe, your patent's invalid, you guys are mean, go away.
Wow.
Is there any legal protection or as part of the system that says if you've got to give up all your sales information, who you sell to and all that
Yeah.
type of stuff, that can't possibly be misused by the other person? They're just using it as a way to collect it for some other nefarious purposes? Is there any?
It's hard to, I mean, what's a good purpose versus a nefarious purpose when we're talking about MPEs? No, at the end of the day, there's certain protections you can put confidentiality, protective orders, so that the information is not public. Some information might only be attorney's eyes only. It can't go to the business people on the other side. You know, it depends on how sensitive the information is. But all those things can be, but again, another layer of information and another layer of costs in fighting and debating these issues. The key thing in most patent cases is what we call the claim construction or a Markman hearing. This is where the judge decides what the term means. This is where the judge decides what a server means. This is what a judge decides what a client means. This is what the judge decides what a wireless network means. Now, I'm giving you very basic information, very basic examples, but if you've ever read a patent, there's lots of words, and some of the words are subject to dispute. What does it mean to be about the tip of the needle? You know, what does that mean, about at the tip, right? There's lawsuits that have spent millions of dollars defining what about the tip of the needle means. Or not needle, orifice. It was a spray type nozzle, and it was the characterizations of what was coming out of the nozzle near the tip. Was it a fine spray or a fine mist, or was it droplets? This is very important stuff in terms of infringement, because once you define what about means, then infringement is pretty binary. It either is there or it's not there. So some of these words are crucial. Most cases, when you get through when the judge says what the claims are, most cases will settle. Not all, but a vast majority. That's where the issues are resolved. Because what I say a server is may be different than what Z says a server is, but at the end of the day, when the judge says what a server is, then I either have it or I don't, and now I know what the case is about. Now I can settle the case, or now I can say pound sand, whichever. And we see these types of things, and the summary judgment is that sort of formalized motion. If the other side's not willing to concede, we're going to file a summary judgment motion. Here's what you said. Here's what they do. There's no dispute. The facts are what they are. Judge, make them go away. We still are not at trial yet. We haven't seen the Barnaby Jones action going on yet. Okay, we are still at there's people are making appearances at court from time to time, but they're not in active trial. No one's on the witness stand yet. So you can see that preparing for trial is expensive. Again, another big ticket. I've got to get him prepared. I've got to get his engineers prepared. I've got to get his marketing guy prepared. I've got to get the expert that's going to say what a server is prepared. I've got to make sure I'm anticipating what the other side is going to say and the arguments that they're going to raise. That's an expense. And then I've got to prepare a written brief of my arguments that I'm going to present essentially at trial.